Started. Hi, everyone. Welcome to the April Zeal call. I almost forgot what month it is, but we are in fact in April. We are a third of the way through 2021, and we have awesome guests lined up for today's community call. A little bit more about our guests in a second, but first we'll start as we normally do with an agenda and announcements. And this is our second time live streaming these monthly Zeal calls. So if there's any technical challenges, if there's any hiccups or delays, please don't hesitate to let us know in the chat, in the YouTube live stream chat, or you can also tweet at us at Electric Coin Co. But so far, it looks like things are kind of moving along pretty well. So for people who don't know me, my name is Elena. I work on the product marketing side of things at Electric Coin Company, and it's my pleasure to host these monthly community calls. We bring together privacy experts, technologists, legal experts as well to just talk about kind of how the privacy and technology intersect. That's something that's really important for us at Zcash and super interesting now that privacy is becoming more of a mainstream conversation. We don't just talk about privacy, but that's definitely been the theme as of late, and it's certainly going to be a topic of discussion today. So I'll kick off the call with our announcements, and then I'll hand it over to our two awesome speakers, Ashkan Soltani and Berjon. They're going to today discuss global privacy control. If you don't know what that is, don't worry about it. We will explain it a little bit later in the call. Okay, so now on to announcements. We have quite a few announcements. These are all kind of the big Zcash headlines from the last community call. So these are announcements in the last 30 days. First, ECC welcomed a new board member, Christina Garman. ECC also announced Unified Addresses Halo Arc and something called the Scientific Advisory Group. So these are different kind of product and company related updates. I encourage you to check out the Electric Coin Company blog to learn more about these improvements or these updates. On the Zcash Foundation side of things, they've been busy too. They recently welcomed Marek Bilic, a cryptography engineer, and they also published a State of the Foundation report, which covers their activity from the second half of last year. If you didn't know already, the next network upgrade, NU5, has an updated timeline and schedule. So mainnet activation is now set for October 1st, and that's really exciting because it allows us to accommodate the unified address addition into that network upgrade. And then these Zeal calls, they're just one of 3 regular monthly calls that we have. There's also the Gardening Club, which is next Tuesday. This is a really great call for any open source developers who want to learn how to build on top of Zcash. I believe we'll have presentations from Renzek next week. We also have Arborist calls, which is scheduled every 2 weeks. The next one is next Thursday. And these are really good for people interested at the more protocol layer discussions. And lastly, we have Zeal calls the last Tuesday of every month, and our next Zeal call is scheduled for May 25th. We'll be joined by Julia Angwin, founder and editor-in-chief at The Markup. So lots of cool things happening in the Zcash community. Thank you for being a part of it, and thank you for joining us on the call today. And these are really, so now, this is another thing I've started to do. ZOG Grants. So this is just helpful. I think it's interesting to see how the Zcash community is growing outside of Zcash Foundation and outside of the Electric Coin Company. So these are the 2 submitted and funded grants in the last 30 days. So, and you'll recall for the March Zeal call, we had kind of 5 or 6 grants. We've had 2 grants, one funded, one submitted in the last 30 days, SEC Wallet Light Client Research, as well as a MetaMask style browser. That one was submitted and is currently under review. So it's never too late to apply for funding. The Zcash Open Major Grants Committee is always looking for people to submit exciting ideas to build on top of Zcash. And if you want to figure out the best way to do that, I recommend the Gardening Club as a good place to start, or the Zcash Community Forum. All right, and right on time, 1:05, that takes us now to our guest speakers. I couldn't be more excited to welcome Ashkan Soltani and Berjon to these monthly Zcash community calls. Ashkan is an independent researcher, technologist, specializing in privacy, security, and tech policy. He was formerly the FTC Chief Technology Officer, as well as a senior advisor in the Obama White House administration. He was also, kind of even before all that, recognized as part of the Pulitzer Prize winning team in 2014 for his contributions to Washington Post coverage on national security issues. Berjon is also an expert in web technology, and he's bringing to the table more than 2 decades worth of experience in both web development and driving standardization efforts. That's something I'm really looking forward to learning more about, because I think how web protocols are standardized is something that kind of happens under the radar or outside of people's main awareness. So I'm looking forward to Robin telling us a little bit more about that today. And he is currently the Vice President of Data Governance at the New York Times. So with that, I'll hand it over to our guests. Welcome. And today we're going to talk about global privacy control. So yeah, I'll let y'all say a few words, and then maybe we can dive into this big, meaty topic that we have the rest of the hour to discuss.
Great. Thanks very much for that generous introduction. And hey, everyone, thanks for having me. I do want to take a second just to reflect on loss of a dear friend and a member of our community. As folks know, Dan Kaminsky has been struggling with health issues for a little while past this last weekend. So just a moment to reflect. But thanks for having me. So I want to talk about the global privacy control, what it is, what it's intended to do, and where we're going with it. And, it sounds like a big, auspicious word, global, as in global domination. I assure you that's not the intent. The global is meant to reflect the idea of kind of a central control that consumers can set on their browser or computer, like a global setting. And that's where the terminology comes from. Just some background, the global privacy control inherits a lot of its philosophy from Do Not Track. I was one of the kind of originators of Do Not Track in 2010, 2011 with Chris Segoyan, and in fact, inspired by Dan Kaminsky, to be honest. I talked to Chris about its background. It was Dan who gave Chris the first idea. But essentially this idea that, at the time we were dealing with a lot of companies that would, for example, continue to persistently track users, even when they had deleted cookies. I had written about flash cookies and this term, this coin, respawning, where companies would say, oh, we didn't realize consumers wanted privacy. We just thought they wanted to delete their cookies. And so we came up with this idea, Do Not Track. Unfortunately, that process got a little bit hijacked in essentially some browsers had went ahead and added it. Some companies had begun to voluntarily honor it, but very quickly industry pushed it to go through the standardization process through the W3C, at which point it got hijacked with industry lobbyists as it would affect, a multi-billion-dollar industry. And we can talk a little bit about that history, but the end of the kind of the result was that it ultimately never became standardized in terms of what its function was. There was, two pieces: this preference expression where you could signal to websites your privacy preferences, which was the goal and intent that we had set out to do. And then this big debate on what companies should do in terms of compliance when they receive that signal, something that we didn't want to try to define, but wanted policymakers and kind of enforcement agencies to weigh in. Unfortunately, the big debate around that the compliance side became so heated that essentially the FTC, where I worked at the time, kind of backed away from the project, and it went through kind of an open standards process in which point industry just undermined it at every turn. Fast forward to 2018, I was invited to help write the California CCPA, the first privacy law in the country, consumer privacy law in the country around online tracking, and helped to write and pass the CCPA and the CPRA. And we can talk a little bit about that. But the key provision, one of the key provisions in the CCPA, to understand it, it allows consumers to object to the sale of their personal information. And sale is defined as any sharing with an entity other than the one you intend to interact, any sharing with a third party, essentially, for value consideration. So ad targeting, ad sales, data brokers, those are included. And for a variety of reasons involving First Amendment concerns and other precedent, the decision was made that in the US, an opt-out system is better. So consumers have to essentially invoke their right to opt out of the sharing rather than have it be an opt-in system. And we can talk about the First Amendment precedent of why that is. It's not great, but that was the safe route to go. But one key provision was that recognizing that consumers, it's kind of ridiculous to expect that consumers go to every website they go to and every service and opt out of the sale of their personal information. There's a provision which provides the ability for consumers to set their browser, their user agent, some device to essentially express their opt-out preferences through a global setting. And while this right exists in the law and including the rulemaking, that consumers have the ability to opt out of the sale of their personal information using a global privacy control, no definition or specification for what that global privacy control is in the law. And we had, at the time when we wrote it, had intended for do not track to solve that purpose or be sufficient for that purpose. But unfortunately, for a number of reasons, the California AG felt that do not track wasn't sufficient to opt out the sale of personal information, particularly because it wasn't clear that tracking meant sale of personal information, and therefore it wasn't specific enough to invoke your right. So a team of us, including Robin, who will speak, who's one of the very early supporters, came together and came up with this specification for a global privacy signal that really kind of inherits from do not track a lot of the provisions, tries to improve on it. But quite simply, it is a mechanism by which consumers can invoke their right to opt out of the sale of their personal information currently. And we can talk about how it might expand and where it might apply in the future. But fortunately, at least in California, the California AG has recognized it as a valid control for opt-out of sale. And we have something like 40 million users currently using browsers or extensions that support GPC, including Brave. The Brave browser has it on by default. And we have major publishers like the Times, like the Washington Post, like WordPress that honor the global privacy signal as a valid opt-out. And so what that means is if you're using Brave and you go to the New York Times, not only does Brave block third-party cookies, which is an important fact, but it also signals this legal right, which essentially means that anyone that that it signals to is supposed to not sell. It's supposed to honor the user's request to opt out of the sale of personal information. And so I'll leave it there, and we can dive into kind of what's next. But I'll leave it to Robin a little bit to talk about how it works and what it is.
Sure. Thank you. Hi, everyone. And so, yeah, the technical description of GPC is not a complex matter, and we can get through it pretty quickly. The goal at a technical level is basically to sort of help restore a balance in the asymmetry of automation. Right now, when a user visits, a whole bunch of sites, uses a whole bunch of apps, all those companies and operators have the ability to automate the collection of data, but on their end, users must always manually signal their opt-out, often on a website per website basis, in a whole range of different contexts. And so, this gets tiring, as everyone knows. Those of you who are in Europe or have been there have been seeing, cookie consent banners all over the place. Those of you in California might have noticed those do not sell footers, but very few people go to the trouble of opting out every single time. And so basically, the idea behind GPC is that the browser does that work for you. It's sort of like imagining that the browser is an automaton, is sort of a robot that just like goes through and like clicks those rights, those opt-outs, or those withdrawals of consent automatically for you, while you just like keep browsing the web as you normally would and as you normally should. And so the way to translate that at the protocol and at the technical level is pretty straightforward. If you've activated the GPC preference in your browser, or if you're using a browser that is privacy preserving by default and therefore might have it on simply by downloading it, then the GPC preference will get expressed through a simple HTTP header, sec-gpc, which will be set to 1 when the control is activated. Or similarly, there's a JavaScript field available through the DOM that can be checked to see what the current setting of the signal is. This is all extremely simple. We implemented it on nytimes.com with just a few very short and very simple, straightforward changes to opt people out of and to make sure that people could gain access to these rights automatically. And it just works. It just works. It's pretty straightforward. And so, from this simple technical implementation, what happens is there is a legal binding layer that translates that into rights that you may have in your local jurisdiction, be it in CCPA or the CPRA for California, other states coming up with GPC-like languages, and there are discussions about how this would work under the GDPR as well. And so essentially, this is a technical translation of the expression of user rights into legally binding effects. And that's pretty much it. There really isn't that much more to say at the technical level for GPC. It's really straightforward. It's meant to be easy to support.
Awesome. Things are rarely that simple, but I guess I have a handful of questions. Primarily, if it's so straightforward, why haven't we seen wider spread adoption? So let me kind of work backwards. For people tuning in, there might be some questions around once the signal is transmitted, how would companies kind of observe, acknowledge, or like honor the signal? So you mentioned it happens at the browser layer. So that's the user signaling to a company that they are opting into global privacy control. What happens on the other end, or what should happen in an ideal world on the company side?
Sure. If I can share the screen, I can share a little bit of details on our website, or I can invite folks to go to our website. We have it pretty well documented, and it would be, I think, useful to break apart the technical compliance with kind of the politics and the legal compliance. But so this is the browser GPC website, globalprivacycontrol.org. We have a banner up top that essentially notifies the user that GPC is detected. This is, for example, the Brave browser, and so it's currently working. And we have a reference server which essentially has some examples of how to detect the GPC value, either server side as a header value or through this navigator object, which you can see here. The entire spec, as dutifully drafted by Robin, is also on the linked off the website. It's globalprivacycontrol.org, and you can see the specification, for example, the sec field name, sec.gbc, and the value of one, and it goes through as W3C standards delineate how it's set up. Importantly, we have kind of an FAQ on the website that talks about kind of who's supporting it, what to do if you're a publisher or a web user, and how you can get involved. And we can talk about your question about whether it's legally binding. The kind of let me leave it there and let Robin speak if he has anything to add, and then we can jump into the kind of why haven't people adopted it and what's next question.
I don't believe I have anything specific to add at this point. So let's just move on to that. Yeah.
So the law. So this, as I said, we're in a unique situation where, first off, as folks know, the U.S. doesn't really have a federal privacy framework. We have specific laws like FICRA and financial privacy laws, but we don't have anything with regards to consumer privacy. California is the first state to have that, and we're expecting actually more. In fact, Florida might pass a similar law to CCPA, which would include, or is believed to include, the global privacy control. And the Washington state bill that was supposed to be heard about 2 weeks ago, but seems to be delayed, also had a reference to making this opt-out mechanism simple for consumers through a global privacy control. And so we're going to see, while we don't have a federal law, we have more states passing laws that tell businesses to honor consumers' right to opt out. And the challenge is that as folks know, this invoking this right has significant cost to business, not in terms of compliance, but essentially to the underlying business model of the internet that involves transferring users' data for the purpose of targeted advertising. And while there seems to be a general acceptance that targeted advertising may go the way of the dodo, and there's new innovations around privacy preserving browsing and advertising, including in Brave, for example, there is a lot of, I think, resistance to that fact at the policy level and at the, compliance level. And so in California, we had this unique situation where we passed this law that says companies need to honor consumers' right to opt out through do not sell requests, including through a global privacy control. But unfortunately, the AG, which is the regulatory agency, didn't specify what specifically the global privacy control needs to be. And so that's where we came along, and we first created this voluntary mechanism that now has been essentially blessed by the AG as a valid mechanism. And so I think while the AG has confirmed that this satisfies the requirement on the law, I think companies are waiting to see whether there's, they're going to hold out to the last possible moment and essentially wait for either explicit rulemaking, right, by the attorney generals that says, thou must honor this, or more likely regulatory action where the AG begins to enforce against companies that don't honor this mechanism. And so if I had to wager, we would see some compliance actions and regulatory actions from the AG first before the rulemaking. I can talk about why that is with regards to the new law, the Consumer Privacy Rights Act, the CPRA that just passed, and how that process is going to go. But I would expect kind of some saber rattling by the regulator as a way to force companies and others to adopt. That said, and Robin can speak to this, there's also a great deal of interest, I think, in publishers and other entities that understand their relationship and the value of the relationship with the consumer and want to prioritize privacy. And we can talk about Apple's privacy changes yesterday. But, and I think there's additional voluntary measures. As I said, some, a number of publishers have already either adopted it or committed to adopt, and we have a number of other major publishers in the wings that are looking at rolling this out technically. In fact, all the consent management platforms, these are the CMPs that do the pop-ups and essentially manage regulatory compliance for publishers. The top ones, like OneTrust, like WireReel, et cetera, also support GPC. So if you're a publisher and you want to support GPC, you just go on their basically their consent management platform and click GPC support. So we're going to see kind of, I think, slow adoption for the well-meaning actors. We're going to see pushback on the ones that are dragging their feet until there's essentially regulatory action. And then I would also expect, some folks to go down, die on their sword and argue that consumers shouldn't be able to opt out. And we're going to see a big battle there, both in policy and regulatory space.
Robin, did you want to speak to the publisher side?
Sure, of course. I think Ashkan's right. There's a lot of interest on the publisher side here. I think people are somewhat slow to move, in part because there's just so much going on in privacy these days, and there's so much that they need to be paying attention to, that GPC is definitely on their radar, but so are any number of other proposals happening at the same time. And therefore the teams that specialize in this have limited bandwidth to make progress. But I'm hearing very encouraging signals from the others. In general, what is important, I think, to understand is that the business interests of publishers are very well aligned with the privacy expectations of people in this case. Basically, publishers benefit when they understand their audience, and they are the only ones to understand their audience, because you can actually sell advertising against that. And so this whole idea of third-party tracking, where others acquire this data, and so, for instance, might know that someone is reading your publication, but then retarget that person somewhere else because it's cheaper to target them somewhere else with the same ad, is not something that is in publishers' interest. And so it has been difficult for publishers to push back against this system that is largely stacked against them. But changes like the CCPA, like GPC, really help move in that direction. And so there's a lot of interest on the publisher side to make sure that they can prevent their users from being tracked by third parties and sort of can escape this this system in which their audiences are being monitored and remonetized by others.
Yeah, I think it would be helpful. I have the slide up, kind of the brief history from do not track to GPC. I think it would be helpful, as we're talking about this, to better understand this process of web standardization and kind of like, it sounds like do not track was launched or originally proposed in 2009. And because there weren't any laws at the time around privacy, it was harder to make the case for it. That's what I gathered from from what I've read. And so it kind of fizzled out in 2019. And now there's a kind of a new effort, which is kind of do not track reimagined as global privacy control. But the wind in the sails seems to be these legal movements like GDPR, like CCPA. But Ashkan, you mentioned kind of this First Amendment precedent. I know we've been talking about several players in the space, like W3C and the AG in California. Can you both talk a little bit about how all those pieces interact, and why? Like, is W3C a government agency? Who
No.
are these kind of lords of the internet that we never hear from?
Lords of the internet. I should get that. I should get a business card with that. No, but I mean, I think, without going necessarily too deeply into the history of W3C and how it works, I think there's one aspect that is very important to understand to make sense of the history that we have on screen here. And that is that in web standards, adoption precedes standardization. So often people have this mental model where the internet standards work in the same way as legislation, where you get a bunch of people together and they vote on a law, and then the law comes into effect. In web standards, it's sort of the other way around. A lot of people discuss things, they iterate on a proposal, but it cannot become a standard before it is adopted. And so in the case of something like DNT or GPC, it was very difficult to get any real adoption without legal backing for it, right? You had a signal without strong legal teeth that supported it, and therefore, no matter how much people might iterate on it and refine the solution and make it technically good, it still didn't have the legal binding to make it live. There was hope that that would happen, but unfortunately, it did not. And so I would say actually DNT fizzled much earlier than 2019. That was sort of like the absolute last gasp, the last slight breath of air, but it died long before that. And so yeah, absolutely. The legal frameworks that are now appearing, that already exist in some cases and are coming up in others, really make adoption possible, and therefore, when adoption becomes possible, so does standardization.
And Ashkan, can you talk a little bit about, you mentioned First Amendment precedent when talking about how do not track or these frameworks were originally proposed, but I missed kind of exactly how that relates to these standards that we're talking about. So can you give a little bit more context on that?
Sure thing. Yeah, and just to give some backdrop, we live, the reference to First Amendment was really around an opt-out versus an opt-in system. A lot of folks have called for why don't we have the right to essentially, or why isn't the default essentially that companies have to ask us for permission to use our information? Why is it an opt-out system rather than an opt-in? And unfortunately, we live under this model after two major cases in the US. One was Citizens United, which folks are familiar with, which says that businesses are essentially people and have a right to speech. And this other less well-known case called Zeal, which was, I think, a Vermont case that said that essentially data is in some ways speech. And so restricting a company's ability to post or share data is essentially a restriction on speech, right? And that's a terrible outcome. I think that's, people take issue with that decision and the precedent, but it has set the tone for a lot of privacy laws. The main privacy law, for example, was immediately challenged under Zeal, and it survived the challenge, fortunately, but it meant that the state AG had to dive in and essentially mount a huge defense. And I suspect every privacy framework we see will be challenged. The more effective it is, the more likely it will be challenged under Zeal. We, when we did CCPA and subsequently CPRA, we received multiple notices that we would be challenged on our definitions of personal information and our essentially our opt-in versus opt-out frameworks. That said, while there is precedent for businesses of speech, the courts have reflected more favorably when essentially it's a balance of a business's right to speak and a consumer's right to essentially speak or opt out of speech, right? And for an example is the do not call lists, right? So we have these concepts of the do not call list in the US, which permits essentially folks to prevent marketers from calling them and speaking to them, right? And essentially, and the courts, precedent has been that courts have reflected more favorably. So as such, the CCPA, when it originally kind of was envisioned, was an opt-in law. Over the course of its development by its passage in 2018, moved to an opt-out framework. So consumers have the right to opt out, right, for this First Amendment concern. That said, adding this global privacy control mechanism where consumers can opt out only once or set their opt-out only once, and then effectively invoke their rights everywhere they go, essentially transforms what would be otherwise an opt-out framework to kind of a stronger, almost more akin to opt-in, because because publishers are not able, or businesses are not able to use consumers' data without essentially getting additional requests or superseding or overriding their opt-out, which there's mechanisms to do.
Just to clarify,
yeah, go ahead.
Just to clarify on that, it's, and this is more kind of like on the how it works section. It seems like companies or third-party kind of data brokers Is it a question of they couldn't be able to use a person's data, or they shouldn't? And then kind of the stick that prevents
Yeah,
them from doing that is like, now that there's a law behind it, they could get sued, or you could, because I know with GDPR, one of the big criticisms is that it didn't have enough teeth, and we're not seeing kind of the European Union bring down the hammer as forcefully as we would like. But I think there's kind of, from the consumer side, a misunderstanding sometimes of companies promising not to share your data, but they collect it anyway, versus companies who just aren't able to collect data because there's no data leakage to begin with. So what exactly is GPC in that, along that spectrum?
for sure. So, and I do want to be clear about this point. I did notice when you first broadcast this talk, there was kind of your usual internet standards naysayers that were like, "Is this a don't be evil bit?" and kind of ridiculing this. This is not that, right? So, just to be perfectly clear, California has a law called the CCPA that says for California citizens, you can opt out of the sale of your personal information, and companies are required to post a "do not sell" link at the bottom of every web page that you visit, as well as honor a global privacy control for opting out of the sale. And when you opt out of sale, companies are not permitted to sell personal information, which is transfer or share personal information to any other party for any value, right? And there's some exceptions for security and whatnot, but in general, companies can't sell your data for advertising or sell it to data brokers. Data brokers can't sell it to other firms, et cetera. And that is required. If companies don't honor that law, they are subject to attorney general enforcement. And there's I think it's $2,500 per violation, and a violation isn't per person; it can be per day, per person. So that has significant fines that the AG can bring. More importantly, so that was the CCPA. The CPRA, which is basically the successor to the CCPA, which adds additional rights to the law, that passed just this last year through a ballot initiative. And a couple key points: it strengthens the law on a number of factors, including that any amendments to the law can't be weakened. They have to be in further of the purpose and intent of the law. And we basically put the sponsor of the bill essentially introduced and sunk another kind of $10 million of his own money into this, because between the passage of CCPA in 2018 and the run up to the ballot initiative in 2020, we saw technology companies and data brokers and others lobby the California Senate to add all sorts of loopholes and workarounds to the law that almost, like, I spent my entire year in 2019 fighting off 2-word fixes to the CCPA that would completely have gutted it for large operators like Google and others, and they were introduced by those operators. And so the CPRA strengthens that to say any amendments can be there to strengthen and fix the law, but they can't weaken consumer privacy. The other thing the CPRA does, which is important with regards to this compliance piece, is it creates essentially a new data protection agency. California will be the first state to have a DPA similar to Europe. And that DPA will be tasked, instead of just the AG, in addition to the AG, the DPA will be tasked enforcing the California law. And importantly, the provision has a chief auditor role. This person can essentially go, as you have in Europe, go and kind of inspect companies' practices with regards to what they do. For example, what they do with the consumer request to opt out. And so this thing has teeth. It has teeth both in terms of resources to enforce it, as well as real monetary penalties for companies that don't honor the law. And so as of today, every website is required to have this "do not sell" link, and every website is supposed to honor a global privacy control opt-out, which effectively, as Robin said, is a robot that clicks the "do not sell" link for you, right? And so under those two legal requirements, you have an ecosystem where there is a great deal of liability on California companies, and we will just wait for the California AG, as well as when this new data protection agency is set up, to see how it is enforced and whether it's enforced. My belief, having worked at the FTC, and I work with regulators, I work with AGs currently on enforcement matters, is the US is often and regularly more aggressive than Europe, particularly because the companies are here in our backyards, particularly in California. And I know, the AG is very closely looking at what their next enforcement actions will be. The thing to think about is there's also some politics with the current California AG just left to go to the administration as the head of HHS. So there's a new AG that's being essentially sworn into California. And in that process, there's kind of a lame duck session where I think there's some kind of, there's some political realities about taking action without a head. But once I think that new AG is in place, and once we have the agency set up, we're going to see much more enforcement actions. And that's all aside from the fact that I said, Florida, Washington State, New Jersey, and New York are all looking at other privacy laws as well. And they're big battles with industry. I think industry learned their lesson in California and is lobbying heavily to undermine those laws. They passed an alternative law in Vermont that's quite weak. And that was an industry-sponsored bill written by Amazon and Microsoft, essentially. But there is a battle in the states, and all of those states will have enforcement provisions until there's a federal law.
So kind of also bringing Robin in for a second. We've been talking a lot about US laws at the state level, right? Because there's no federal law. But GPC is not standardized yet. So can you talk a little bit about kind of outside of the legal world or the legal political world on the technical side of things, kind of what are the steps that need to happen in order for something like GPC to be a web standard or to be accepted as a web standard?
Sure. I mean, I think the most important step for GPC to become a standard is to see more action on the legal and policy front. That is really the primary driver here. And so as we start seeing new jurisdictions coming online with GPC support, that is a very strong signal that this technology is gaining traction, that this approach to privacy, or at least this contribution to privacy, is gaining traction. And therefore that will directly feed into the standards discussion. And then, it's a question of priming the pump. So we're at a decent stage today. If we see more jurisdictions coming online, we're going to get more technical implementations as well. So I would expect incrementally more websites, more browsers. I was going to say more CMPs, but I think we have almost all of them by now. And so that is basically, once you start seeing this sort of like forward movement, of which we're at the beginning, but seeing really good movement, the steps to standardization shouldn't be, far away.
Great. And then the internet, this is probably going to sound like a goofy question, but the internet is funny in that it's borderless in many ways, but then in very concrete ways, it fits within a jurisdiction depending on kind of like your internet service provider, the infrastructure that you live in, or kind of what Ashkan was saying, where the companies are based. If the internet company is based in California, it's subject to California jurisdictions. So how do you see kind of what we're seeing play out at the state level, at the national level, and also at the global level? How do you see all these laws kind of converging? And then kind of in the same breath, like I know Google recently made some waves because they're changing the way that they do cookies. That's literally the extent of my understanding of it. So it would be helpful if you could kind of talk a little bit about, Google's trying to do this thing with cookies that does or does not advance privacy, and then global laws around privacy, like what we're seeing in India, where it's a broad sweeping law, but it has a huge backdoor just for government users. How are you seeing kind of all of those different trends converging?
Sure, you want me to take it or Robin?
Both, either both. Jump on in.
Maybe take the jurisdictional one, and I'll take the technical side afterwards if you want.
Sure. So I think we have a good model for this, and while it's true that there are real borders in terms of whether you're a California citizen or whether it's a California company, we have historical precedents for these types of laws around things like the CARB standards for automobile emissions and for consumers for automobile safety, even where California was the first to pass the seatbelt law. California was one of the first to provide emissions guidance. And then those became the national standards, both in terms of other states passing similar laws, but importantly, the realities of essentially compliance, where companies realized that they needed to build a car that would pass California safety or California emission standards. So that's basically what they built their cars to, rather than tool and retool their factories to have essentially state-specific laws, right? Or state-specific cars. And so I think we'll see more of that. For example, Microsoft has already said that their compliance framework, they honor essentially CCPA rights for the entire nation, not just California. And other companies have taken that position, right? Just at the end of the day, compliance is time intensive and costly. And so companies are going to try to meet a particular standard and try to meet that standard nationally rather than on a state-by-state level, right? Because it becomes very hard. And that's actually something to just touch on briefly, which is that is the strategy. For example, I mentioned the Virginia law. I've been involved in a number of kind of closed door kind of panels and hearings where I've listened in to industry lobbyists and lawyers essentially push for this very thing, which is that now that California has this strong law, the goal is to essentially pass weaker laws in other states, right? As a way to demonstrate two things to Congress. One is that they would argue that because there's a patchwork of laws, there needs to be a federal law that essentially covers the US and that preempts the other laws, that essentially makes it so that it's easier for companies to comply, which is problematic if there's a weaker law that preempts the California law, right? So that basically brings down. And two, by introducing the weaker laws like in Virginia, and there was a similar attempt to do so in New Jersey to provide an industry-backed law. The goal is to show Congress that there can be a workable standard that's different from California. And as you know, because this is so technical and so nuanced, right? So an example of one of the weaknesses in the Virginia law versus the California law, the Virginia law defines personal information as any information that can be reasonably linked to a natural person, right? And what's challenging about that is, as you know how online tracking works and how cookies work, they're often pseudonymous identifiers that never refer to Robin by name, but just R1234. And I forever refer to him as that. I know everything about him, right, around what his behaviors are, but I never refer to him by name. Therefore, that information falls outside of the protections of the Virginia law, and therefore consumers have no rights to that law. And so those little nuances, which policymakers don't quite understand, is exactly what industry tries to exploit in passing weaker laws. And their hope is to essentially use this patchwork to promote or justify federal preemption, right, of a weaker bill. And so that's a lot of the stuff that I've been working on. And Robin, do you want to talk about some of the kind of technical developments?
Yeah, sure. I mean, I think, one thing that definitely, interested the Times in GPC right away is that a lot of these jurisdictions are springing up with relatively different privacy regimes, and it's not where the company is located. In many cases, it's not where the company is located that matters, but it's where the reader is located that creates establishes the legal regime. And so for a company with a global footprint, you're basically dealing with a whole bunch of different privacy regulations, and that's where standards really help. And so something like GPC helps companies, comply with privacy regulations and with users' expectations across the globe without having to reinvent the wheel for every single jurisdiction that comes online. And the way this relates to other work being done on the web in support of privacy, I mean, you mentioned Google stuff. Google is actually not at all the first to propose changes to the way third-party cookies work. They're actually it's the last browser to come to the table on this, but they've made a bunch of proposals, and basically because they are the largest browser, everyone's paying attention to the fact that third-party cookies are essentially going away across the board. And so what's happening in that space is that a lot of functionality was basically riding on the back of third-party cookies, some of it justifiable, some of it a lot less so. And so people are inventing new technologies to support the same functionality without third-party cookies. And there's a bunch of different standards that are being proposed in this area. Some of them I really would not recommend. Others are actually quite good and privacy supportive. It depends. It's a mixed bag. But GPC actually fits in to that new push for a batch of standards in support of privacy. It's complementary and not in competition with these other standards. So it's basically part of a let's improve the whole of the web approach.
Awesome. Well, I mean, I'm looking at the time. Time flies when you're having fun talking about privacy and web standards. And I feel like things happen slowly and then all at once. So these conversations around privacy, encryption, how data works, they're nothing new. As we saw at the beginning of the conversation, Do Not Track started over 10 years ago. But it does kind of feel like things are coming to a head, or that there's a paradigm shift on the horizon. I don't want to put either of you on the spot. I'm not going to make you guys make any predictions, but if you could share with us kind of like some parting thoughts about looking ahead, what can people look forward to in terms of how GPC might impact their experience online in the next year or 5 years even, that I think would be a great note to end on. And then of course, if there's any ways that people can get involved with the project or support the project, we'd also love to hear about that as well.
Great. Rob, why don't you go? I've been going first every time.
Sure. I mean, in the broader space of privacy, I expect continued chaos for the next years to come. There's going to be
fire and brimstone.
Yeah, I mean, of all kinds. It's a heavily contested space in every single dimension, and this is going to continue for the time being. I do think that GPC is one segment of it that is actually sane, where we're having reasonable discussions and making progress. And so I think it's going to be one of the cornerstones of an improved experience online for people who will have better privacy outcomes, through browser automation. It's not going to solve everything. There's still going to be a remarkable amount of chaos outside of GPC, but I think at least every little bit that we can contribute to make things better for people helps. And I think GPC is a substantial contribution in that area.
Yeah, just to follow that, I think fundamentally every 20 years or so, these type of battles come around, and there's we're at a inflection point for essentially the battle of the soul of the internet, right? Around consumer privacy and consumer rights, but also tied into that is antitrust and content moderation and free speech, right? And so there's going to be essentially a push to remedy some of the problems of the internet, including hyperpartisanship and platform power, as well as privacy. And so something is starting to happen and will need to happen. And so the question is the what, right? The forces at play are incredibly well-funded and well-invested. And there will be essentially a goal to pass something that essentially on the surface looks like it addresses issues, and not just pass something, either pass something legally or provide technical solutions or mitigations that look like they address the solution, but still permit the core business model and the core function of the current internet economy to work as essentially, not to overuse the term surveillance capitalist ecosystem, or however you want to, attention economy, whatever terms you want to use. And so I think there are opportunities to, one, use standards and use kind of laws and technology to promote the values we believe in. And I know Zcash and the Zcash community are very effective at doing this. And then I think, two, it's important to kind of engage and clarify when these things fall short, right? So Robin was being very generous on some of the technical standards, but some of the privacy technical standards essentially work opposite the goals we set out. For example, when we set out GPC, and to be fair, GPC is simply, and the reason it's so simple is it's intended to be a mechanism for consumers and users to voice their preference, right? Their privacy preference. And then we're looking to laws and requirements on companies and good faith actors and legal requirements on what companies should do with regards to that preference, whether they need to honor it. But the goal is to allow consumers a voice to express to companies, I want privacy to the degree that I have the right to have it, right? And so it's up to us to essentially create legal requirements and create the force, to pass laws to have companies honor those. But it was for the same reason that, it was for this reason that we essentially set out to do GPC, because at the same time this law passed, there were murmurings in the community, and then there is currently examples of protocols that are designed to permit consumers to invoke their privacy rights, right? For example, but effectively reduce their privacy rights. For example, there are people out there trying to promote a GPC kind of protocol that would essentially signal to companies your right to opt out of sale, essentially, of your personal information, but do so only by providing a cryptographically unique identifier that they would send to everyone down the chain, right? A unique identifier, pseudonymous identifier that reveals who you are and essentially circumvents any other browser privacy protections or any third-party cookie blocking or any of these technical mitigations that Apple and Google are putting forth, right? So the protocol would say that in order to protect your privacy and invoke your legal right, you essentially have to identify who you are and do that so companies reserve the right to do whatever they want with that identified information in addition to opting you out of the sale. And fortunately, that goes against the rulemaking the AG has set forth, that the information used for an opt-out can't be used for other purposes, but it won't stop companies from trying to convince publishers and others to adopt this technology and gets traction. And unfortunately, policymakers, compliance teams, a lot of folks don't get these subtle nuances. And so that's a real risk, is I think the community can not only engage in adopting the standard, supporting the standard, downloading a browser that supports it, or pushing companies like Apple and Mozilla who are interested but that have not yet implemented the standard. But I think the community can also serve to clarify when these little subtle distinctions in the law or in legal requirements come out, where companies are like, oh, it's anonymous data, when in fact it's a robust, identifier that can be identified using rainbow tables or something. And so that's, I think, another role, is providing clarity around these really nuanced technical topics.
Yeah. Well, I mean, lots to look forward to in the months and years ahead. I think that's such an important point to end on, though, that, be careful of a wolf in sheep's clothing, right? Not all privacy laws do the same thing. And I've certainly seen some movements that look like, oh, in order to protect your privacy, you need to give us all your information forever. And we won't tell you what we're going to do with it, but we pinky swear that
Right.
It'll be really good, and you'll have the opportunity to consent whenever you want. So yeah, I guess call to actions for people tuning in. Check out globalprivacycontrol.org. Download browsers that support this tech standard, and keep informed, stay tuned, see how these discussions evolve. Ashkan, Robin, I can't thank you enough for joining us this month. It's been a really great discussion, and I thank you all for all the work you're doing, not just at the policy level, but also at the technical level for advancing these type of standards. So that's this month for the Zeal call. And then we also have, looking ahead to next month, May 25th, Julia Angwin, editor-in-chief and founder of The Markup. The Markup has actually been doing a lot of good research on which privacy laws are the real ones. So it's been great because last month we had Brave browser, we had Yan Zhu. She's contributed to a lot of W3C standards. This month we had you guys, and then next month we have Julia Angwin. She'll talk about some of the markups tools like Blacklight and Citizen Browser, but then she'll also discuss how their investigations are holding tech companies accountable to honor these standards and to actually, honor what customers' preferences are. So it was a jam-packed discussion today. Thank you guys again, and I wish everyone a good rest of your week.
Thanks a lot for having us.
Thank
Goodbye.
you.
And say hi to Julia next month.
I will do. I will certainly send her your warm regards. And I invite Robin and Ashkan, please stay a part of the Zcash community. I'm sure there's a lot of people on the Zcash side of the world who would love to hear you more often and hear you chime into the wacky world of digital currencies. So with that, I'll conclude today and see y'all next month.
Thanks.
Thanks.
Bye.